part of a financial plan has to do with legal documentation. And today we've got elder law attorney Sanford Mall. He is a certified elder law attorney by the National Elder Law Foundation, national member of Council of Advanced Practitioners, and a ton of other things. We don't have enough time for all of that. Sandy, welcome here to Jay's Corner.
Well, thank you, Jay. It's always a pleasure to be in your corner with you. I'm honored to be among an esteemed colleague. Thank you. I appreciate the opportunity.
So you're here and you've been practicing as an elder law specialist. But before we get to that age division, what I'd like to do is talk to the population, a wider population, meaning the nuts and bolts, if you will, the setup. So if we have a blank piece of paper for people who are not familiar with the importance of trusts, wills, medical directives. I'm going to step back for a few moments. And why don't you give us a few moments to tell us what the importance of these documents is?
Yeah, that's great. Thank you, Jay. It's always good to make sure, even when somebody does have a background, that you review the basics, because it's easy to forget some even obvious things. So, and by the way, I also have some good visuals, which I'm not prepared to present right now, but if any of the listeners want it, perhaps they'll be able to communicate back with you. I've got good visuals that help solidify the information that I'm going to share. And I also have a what I call a client-focused estate planning design questionnaire that helps, again, re-explain each of the legal documents, what I call the tools, and how all those tools work together, and whether, so people can decide whether they've got what they need or they should get things reviewed. Anyway, let's get right into it. So we're all on a timeline, right? Today, Jay and I hope that we're both alive and well. The alive part, I think we're there. The well part, well, we're here. So
depends on the moment.
we woke up on this side of the green, so to speak.
Right.
So anyhow, in our lifespan, there are things that we should be prepared for that could happen. For example, all of us have been through experiences of being unwell, being sick. With COVID, of course, that came into sharp focus for many, many families about the fact that, we never know what tomorrow may bring. And so preparedness is important. In Michigan, Michigan law does not provide for a family member, even if it's a spouse of 50 years or a parent for an adult child, does not provide for a family member to make medical decisions. So let's just start with something really basic. It has no bearing on how much money you have, whether or not you have what most people consider to be an estate. It's instead protection of the individual. And the way to stay out of the probate court system, the way to avoid having a judge make decisions on your behalf or appoint a stranger to make decisions on your behalf, is to have the medical power of attorney. And in Michigan, we call that a patient advocate designation. So the patient advocate designation, you absolutely.
I got a quick question for you before we keep going, and sorry for interrupting.
Yeah.
You pointed out Michigan.
Yeah.
So this is a state by state statute,
yes.
Meaning every state has a different set of conditions or a different name for this document?
Well, yeah. Okay. So two things. One, let me break that down to two parts. The first is, I said, in Michigan, we do not have family consent. Other states do. So in other words, if this is being viewed by somebody in a different state that does have family consent, then it's maybe not as urgent as it is in Michigan. And yes, the document that we're talking about, the one that empowers in Michigan a surrogate decision maker, somebody else to make decisions when the patient is no longer able to make decisions for himself or herself. That document is a durable power of attorney for healthcare, but also known as a patient advocate designation, because you're appointing somebody to speak. Now, by contrast, some states have, living wills. We are not. Michigan is not a living will state. we recognize the validity as being something that provides evidence of a person's wishes, but the living will in and of itself is not what controls. Other states, a living will may control. And in other states, as I said, they may have family consent. So that's all excellent point. My point is to start in baby steps to say what
Right.
is appropriate for everybody that's
Right.
over the age of 18. And
Sure.
the answer is having some level of power and authority that you've granted to someone else, someone you know and trust, that'll make decisions on your behalf that will be consistent with what you would want when you can't make those decisions. Well, we'll build on that. We're going to move from medical now to financial. So the companion to that document is a financial durable power of attorney. And that document, like the medical one, is appointing someone. You're appointing an agent under the financial power of attorney to act on your behalf, to do things that need to be done in your financial and maybe legal decision life. When you can make those decisions for yourself and handle those transactions on your own, then you do. But when you can't, having that document in place avoids the need for a conservatorship. The medical avoids the need for a guardianship. That's a probate court proceeding where the court takes control and decides who's going to be in charge. And the other one is a conservatorship, and that's designed to help protect assets. And so if you don't have the power of attorney, appointing someone with the scope of authority that's needed, then the court is going to have to get involved. Jay, it looks like you have a question.
I do. And Sandy, like what ends up happening is you're going to mention something. I've been waiting for this conversation actually with you on a recorded line, so that because the number of different questions, follow-up questions, I think that a lot of the audience will have. So you have basically stated two different distinct roles, meaning one for administering healthcare decisions, which services you would choose to accept if the person can't decide. You have another one on pure money, meaning financial matters.
Right.
Is it your opinion? How do people decide? Because this is two separate roles. Is it your thought that one person handle both roles, or
that's a personal choice.
Multiple people.
That's absolutely a personal choice. I'll give you an example. I have many clients. We have thousands and thousands of clients, and I've gone and I've probably done planning for 10,000 times. I've probably done trusts and wills, but let's put all that aside. It only gives me a basis then for answering that question, not what is legally right or wrong, because legally you could have the same person, right? It's not a legal question. That's a personal choice question. So it's not uncommon, for example, for, I'll just make this up, husband and wife to decide, well, our son is a financial planner, so we're going to let him handle the money. Our daughter's a nurse, so we want her to handle the medical, right? But they don't have any problem with either of them doing both jobs, or if they needed to. It's just a question who's in the best position at that moment. Another reason why people will segregate the responsibility is exactly that. It's a responsibility, and they don't want to burden one individual with everything, so they will sometimes do that. And often they'll also want to choose to have a co-relationship, meaning I'm going to have my son and daughter both do it. Well, that kind of works better in the financial power of attorney. It's still not great. And the reason is logistics. It's just a matter of which financial institution is actually going to allow them to act independently if that's what they want, or if they are required to work together. Well, you might end up getting into a conflict situation, or somebody might be out of the country when one of them's out of the country when something is needed and they can't, and the other one can't get things done. So the logistics is an issue. It's interesting that you asked the question, because it's one of the areas of counseling that we go through with many of our clients. We go through a lot of Q&A through the process for them to come to that decision of who they're going to appoint and why. Some, for example, in medical decision making, it's more important to have somebody that is local It's not essential, but it's better. Why? Because they can show up at the hospital when needed, right? Right. So it's just practically better. Financial, well, with the world being the way it is today, I mean, they could be in Timbuktu and still handle the financial transaction. So there's a lot of considerations in that. That's a great question, Jay. Thank you.
Timbuktu,
So
that's otherwise known as East Lansing or Columbus, right? Those are right? Anyway,
it depends on your orientation.
Different recording.
Yeah,
Okay.
depends on anyway. So what we've talked about now, and my visual is actually like a goalpost, like a football goalpost. Is I got two legs that are holding up the middle, and the middle section at the bottom I have alive and well, A and W. In the middle, I have A and W with the W crossed out. That's alive, but not so well. And at the far end, I've got the A crossed out. Well, we know what that is. I call that not so alive because it's a better euphemism than said. Anyway, we'll move on. So those are our 3 points of time. Now, alive and well is now. Eventually, when you're gone, that's then. In between is the drama of what plays out in life, and that's our whole elder law discussion we'll get into later. But at the two ends of the two goalposts, on the far right side, which is the terminal point of the timeline, the far right side, on top of the goalpost, I have the word will. Okay. Because a will is a legal document that only goes into effect when you're gone. It has no legal impact at all while you're alive. And a will is a ticket to probate court. And what I mean by that is somebody dies and they own assets in their own name. And they think, well, I've got a will. It's going to take care of everything. It doesn't. If that's what you've got and your estate requires some type of action in order to transfer assets, in other words, from the person who passed away to their chosen persons to receive the inheritance, or to even just pay their bills, someone has to have the legal authority to do that. That person's called a personal representative in Michigan. Some states it's executor, some, they have other names, but it's a personal representative. The personal representative gets his or her power and authority, not from the will. The will is only sort of teeing it up. The power and authority actually comes from the court order. So a probate court judge issues an order that says the person named in the will has the authority to act. Now that person then can go and transact business and do what needs to be done, but that's all through a probate court process. And it's public, and there's an inventory fee, and there's other filing fees. All of that probate court process is what you can anticipate, whether you have a will or you don't have a will. If you've got any assets that are in your sole name without beneficiary designations, probate is what's going to happen. On the other end of the spectrum, we've got the trust. And
okay, before that, just for a moment, about the probate matter.
Yeah.
So you said there's like this is a public hearing where my brass elephant is going to show up on an inventory on where it's going to go? Is that?
Yeah, well, it's kind of like that. First of all, your will is filed in the court. It's admitted to probate. Secondly, the inventory is filed and an inventory fee is paid. And third, there are different levels of proceedings or events that occur through the court, but it can be anywhere from a informal, unsupervised to a fully formal and fully supervised estate and process. How is that determined? Well, the will might say this is an unsupervised and informal probate. And that's fine as long as there's no objection. In other words, as long as there's not an interested party or a creditor that comes up and says, hold on, slow down, we got to do this differently. And then the court gets involved and says, all right, judge is going to protect the individual that's raising the concern about the fact there might be something that's not quite right. So that's what happens through probate. And by the way, the probate process, whether it's guardianship, conservatorship, or the decedent's estate, meaning after somebody dies, all of that's public. And the thing that really scares the heck out of most people
No,
is when I
thank you.
tell them, if you're going to go and you're not going to have a power of attorney with sufficient authority for your agent to do what needs to be done, that information goes public in the probate system. And if anybody questions this, go to the probate court. Just go there. If you know somebody who's got a conservatorship or decedent's estate or guardianship, doesn't matter. Go to the court, go up to the counter and say, I want to see their file. They don't ask you if you're a lawyer. They don't ask you why you want it. They don't ask you what you're going to do with it. They just say, get the file for you and they hand it to you. And then you go through and you say, okay, could you make copies of this? And they say, sure, 10 cents a page, a quarter a page, whatever it is. And you walk away with that very, very private information that was made public through the probate system. And so probate court, there's really only the actors that I know that enjoy probate court are the lawyers, because we make money in probate court, right? But the average person, they don't want their estate tied up. They don't want their life tied up in probate court. We want to do what we can to avoid it. So good estate planning, the best estate planning, looks at that boogeyman, what I'll call the probate court boogeyman, and does what it can do to help make sure that the individual that has such a plan can stay out of the government's control, can stay out of the probate court being involved in their life or in their management of their estate. All right, so the trust, as I was saying, which is sort of the will versus trust debate that has, for those people that know, which one is better? Well, again, I don't say one is better than another. I say one provides more function than another. For example, the trust, a revocable living trust, and there are hundreds of different styles of trust. We'll just, for this purpose, for estate planning, it's revocable. You can change it. It's living, meaning you created it during your lifetime, and it's a trust. A trust is effectively an empty bucket. It's a legal document, ink on paper, that sets up an entity called a trust that is able to hold and own assets. And it can receive assets as a beneficiary as well. So the trust sits there after you've created it, while you're alive and well, and it stays in effect while you're incapacitated. So any period of time you're not so well, a successor trustee who you've identified can step in to take over. When you first set it up, you're the trustee. You're the person who sets it up, you're the trustee, you're the beneficiary. You're wearing all three hats. If you become incapacitated, you're still the one who set it up. That'll never change. You're still the beneficiary because you're still alive and it's for you, but you're no longer the trustee because you can't manage. So you've got your trusted surrogate to step up to manage on your behalf. And when you pass away, the trusted surrogate that you've identified handles the administration. You're no longer the beneficiary. It's the people you've named after you that then step into that role. And once you've passed away, the trust is now irrevocable. So it can no longer change.
I see.
So it starts revocable, it ends up irrevocable at death. That's the typical scenario. And then in the body of the trust, you define who your family is, who the beneficiaries are. If you decide you don't want someone to inherit, you can also disinherit through a trust. And then ultimately there's the whole section of what happens after debts, expenses, taxes are all paid, and the estate is administered, who gets what and how they get it. So, for example, many people want to just, well, thank you for asking. So many people will say, well, I just want my kids to get it outright. I'm not going to control from the grave. And that's fine. And we have a further discussion. Tell me more about your kids, right? Sometimes it's like, I mean, I hear about a special needs child. Sometimes I hear about a spendthrift child. Sometimes I hear about other skeletons in the closet. Maybe
Right.
the outlaw child is not their favorite person, right? Maybe they're concerned about any number of things. But rather than just take the client's, I almost call it a flippant, non evolved kind of an answer, in part because they don't necessarily want to unload the information until they have the rapport with you, so that you can know that they know they can trust you. So then eventually we get to, and eventually sometimes could be minutes, sometimes it could be seconds, and sometimes they come, with that on their sleeve. And other times I have people who are more resistant. But my job, as I see it, as a counselor, is to work through that, because ultimately you want to make sure that the people you want to leave money to or assets to, get what you want them to get them when you want them to get it, and how you want them to get it. So if we're starting out with a special needs individual, for example, you don't want them to get an outright distribution, especially if they're on government benefits, because then it will impact their life and their government benefits. So that's an obvious one. Same thing with a spendthrift child. You wouldn't want a spendthrift child to get a huge windfall. Or let's say we have got someone who has got a history of bipolar condition. And when they're in the manic phase, they go in a spending spree, right? You want to have some control, or you're concerned about whether or not a child might be in a bad relationship. And if that relationship ends, you don't want half of their inheritance going to their ex-spouse. So there's any number of things that we talk through. And when clients have thought about it and they make a decision, then that's the nature of the provisions that we make, that are sometimes very different for different beneficiaries, and sometimes they're the same. Again, it's personal choice. Which is better? That I leave up to my client. I'm an educator. I tell them, here's the basics. This is what you need to understand. This is what a will does, probate. This is what a trust does. It has a promise, a potential for no probate. I'm going to come back to that in a minute. So we have the trust on the other end, no probate. Usually when I say that, people go, I like that one. It avoids the probate boogeyman. So that's a good thing. But let's talk about why trusts, even a well-designed plan with all of those documents, why their plan could still fail. There's really two main reasons. The first is it's out of date. They haven't kept it up. They did it 20 years ago, even 3 years ago. If your life circumstances have changed dramatically, it's a good idea. It needs to be reviewed. If the document doesn't keep up with what's happening in your life, it has a greater potential to fail. It's not going to carry out your wishes in the way you would want. If you want it to do that, you need to keep it up to date. So that's number one. And the number two, a reason, is that it's not properly and fully funded. Funding the trust is a huge area of what I'll call a gap in many, many people's planning. And what do I mean by funding? That's changing title of the asset to the trust, because you want this trust, this empty bucket that we've just set up, to hold your assets. Now, you can't hold all your assets while you're alive. For example, IRAs, you can't title into your trust while you're alive. But you want to be able to, with good thinking and guidance with your professional advisors, decide how you're going to handle your beneficiary designations. More on that in a minute. But all of the assets that you can easily move into your trust, like an investment portfolio, it could be in J.O.'s name today. Tomorrow, it could be in J.O.'s trust. You still have all the authority, all the ability to do everything and anything. That don't need any special tax return, don't need any of that. It's a grantor trust. It uses your social security number, but it's your alter ego that has that succession of management and control, and ultimately the ability to transfer pay your debts and expenses when you're gone, transfer to your beneficiaries in the way you want, and do all of that without the need for probate.
So
And even when
in a perfect world, we've got 27-year-old Sanford Mall, promising attorney, world beater. In a perfect world, then you would have suggested, if you could put yourself in the time capsule, which doesn't exist yet,
right,
create a trust, and then when you purchase your first home, open brokerage accounts, et cetera, et cetera.
right.
The actual owner then be the grantor trust that you just described. That's your perfect, if you could make a perfect world.
Well, I'm going to hedge here a little.
Okay.
I'm a lawyer, so most questions have an answer that says it depends.
Okay,
right. All right. So let me give you a reason why.
You have bills to pay, Sandy.
Yeah, right. No, I'm going to tell you the reason why. There's very good reason.
Okay.
So
for
example, as I said before, you wouldn't put your IRA in the trust because that triggers a tax problem. So there's a consequence to every action. If you move your bank account, which for going back in history, when I first did this work and for many years, we always moved bank accounts. But you'd go to the bank and you'd have the JO checking account, and the banker would say, oh, you got a trust? Sure, we'll just change the title to this account because it's still under your social security number. We'll just change the title to the account to the JO trust. Well, banks don't do that anymore. That's because of bank failures and re-regulation and deregulation and everything else. The financial world has changed dramatically. Financial institutions, for the most part, are still able to change accounts. But usually now, when you change the name, the title on an account, they want to close one account and open a new one. Well, it's not a tax event, so you're tax neutral. But if you've got anything connected to those accounts, automatic deposits, automatic debits, whatever they are, bill pay, you got all that attached to that account. If they're telling you got to close it, well, that's a monumental headache. So these days, for those types of accounts, we generally tell our clients, leave it the way it is and just attach a TOD or POD, meaning a transfer on death or payment on death designation. And that goes back to the trust. So it pours into the trust when you're gone. Your agent under power of attorney still has authority to act on the asset while you're alive. But it doesn't go into the trust until after death on that scenario. But for the most part, if we can transfer, but what don't we transfer? In addition to IRAs, I don't transfer cars into a trust, right? From a liability perspective and also from an asset transfer perspective. We don't need to transfer cars or other vehicles. Now, if it's a collectible car, that maybe that's different because that's more of an asset that might appreciate, or your elephant, for example, might be something that appreciates. And then anyway, the whole point is funding is deceptively simple to talk about, but it is complex in a number of ways, and that's why I think people tend to get shy. They don't understand it. They're not sure what to do. They're not sure if they're doing it the right way. And frankly, they find out that it's not as easy as it sounds, even though you might go to Bank of America and go, I've got a trust. Bank of America could take, well, first we're going to have our legal department look at it. And after the legal department looks at it, then we're going to need this, then we're going to need that. And people just, they get what I call planning fatigue. It's like, it's too much stuff. I don't want to have to deal with all that. Why did we start this all in the first place? We got that crazy lawyer who told us all these things, scared the heck out of us about the way the world really works instead of the way we want to believe it works. And then they tell us to do all this work and we can't get it done the way they said, or at least we're running into these roadblocks. Why did we do all that? And that's why we offer that extra service of helping clients understand that process, learn exactly what they need to do on an asset by asset basis, And then they can either take the steps themselves or they can hire us to do it. But if you don't do it, let's just be clear that what you've got then is an incomplete plan, a plan that is by design going to require a probate that will come back to life after you're gone and say, okay, here's all those assets that didn't get properly funded. Now we have to go to probate, get the probate court to appoint the personal representative, and then the personal representative has the power to move the assets into the trust. The trust will still ultimately control the disposition, where everything goes, but why go through probate if you can avoid it? Yeah. Okay,
So
long-winded answer.
You know, great information, and this is exactly why I wanted to be on here with you. What you've mentioned a number of different situations where there are life events or certain things that somebody did not consider. And of course, you're not going to be able to, crystallize it in 2 to 3. But if you could overgeneralize, in addition to the 2 that you mentioned, what are the things that, due to consumer fatigue, due to preparation fatigue, those type, or fear of it, but what other mistakes, even before thinking about approaching Sanford Mall and your services, do people have, do you think? I mean, you mentioned the probate matter. I think that is, very clear.
Mm-hmm.
Some people, go through it once, or they heard somebody go through it, and then like 9 months in probate, they say, okay, whatever that is, I don't want to go through it.
That's right. Yeah.
But in addition to that, is it mainly a mentality matter about, okay, having to face the fact that we're not going to live forever, and then we have to think of it, or you see what I'm saying? In other words,
why do people not do it?
Why do people not do it?
Yeah. Or if they have done it, why do they not revisit it? Or, why do they leave it sort of incomplete? Well, procrastination is it's a human trait. What can I tell you?
I can tell you
we all do it, right? The answers, I mean, I could ask the same question of you. Why do people not have a financial plan? Why do people not go see their financial advisor regularly to update and to, I mean, all these things are incredibly important if you want to get optimal outcome. But most people don't live in that frame of mind. They're not thinking about those things. And so, like you say, maybe it's superstition to some degree. And I have had people that have absolutely told me, I don't want to talk about these things because I'm afraid of conjuring up the worst, right? And I mean, that's a personal choice. My reply to that is, well, however bad you think it might be, just think of how much worse it is if you're unprepared, your loved ones are unprepared, you have no plan in place, and strangers are making decisions about everything, right? Then, of course, I'm that lawyer that's scaring them. But they don't have to believe what I tell them. They can go to probate court and watch the proceedings. They're all public, remember? You can watch and see how these dramas play out. Where it really hits people most, in my experience, is it hits them most in 2 ways. If they've got a loved one that they're really concerned about their welfare, they'll overcome their procrastination because they want to make sure that person is taken care of. That could be a spouse, it could be a sibling, it could be a child, it could be a parent, but they want to make sure, and they want to be as responsible as they can. And if they've got even a little bit of insight from what modern media is now put in their face, they're going to know that people like me exist that can help guide them through the process. And I never do it alone. I always say, look, we're better as a team. If I've got your financial advisor on board, if I've got your CPA or your tax advisor on board, and me as your legal advisor, we can help make sure we're looking at your life through a common lens to help make sure that it's going to be best for you. But I think that's part of it is just procrastination is human nature. The other part is superstition, and probably financial. I mean, we cost money. There's no 2 ways about it. And lawyers get a bad rap. And I'm not saying that all lawyers don't deserve it. some lawyers do probably deserve the bad rap. I mean, we aren't inexpensive, but what we're doing is such an important cornerstone element of your responsible adult life, to make sure that things are taken care of, not only for your benefit, so you don't go through that added drama and trauma of not having things organized and in place, but that your loved ones don't have to go through it, right? So it's just a matter of turning this on its head and having people recognize that even though we didn't learn it in school, even though these are things that we thought, we grew up thinking that this is only for rich people, right? We have to have people really understand that these are basic things that everyone should. And that's why I started with the medical power of attorney. Because you think about a child who goes off to college, right? They're already over 18. Their parents can no longer make medical decisions for them. And they're off in a strange area. What's going to happen? They don't have anybody appointed to make legal decisions for them. Really bad result, right? So
the long list. On the superstition, my mother has the other take, which is that if you have insurance, that and buy it, that guarantees you're never going to need it.
and you know, that's a funny thing. Your mother sounds like she may have attended one of my seminars, because I tell people when they bring that up, that's one of the things I say to them. By statistics, people with estate plans live longer than people who don't have estate plans. And that's probably the same what's true with financial plans. People with financial plans generally tend to live longer than people, you know, statistically. So if you want to add years to your life, do your financial and estate planning.
We don't have financial advice on the podcast and broadcast, Andy. But if you believe in superstition or you know, causation and correlation, you know,
right,
soft lines, then maybe perhaps.
Exactly.
Let's now switch just here in the limited time we have. You are certified as an elder law attorney. So explain to the audience why, meaning that you've explained, we've got the cornerstones, they've listened to Sandy Mall, they've come to them in their mid-40s, but why now do you have these extra labels attached?
Okay, so unless there's a special needs or disability component for somebody in their mid-40s, they're really not yet at the stage of life where they're going to appreciate some of the other elements. If somebody in their life, like their parents, are going through some challenges, then it's more in focus. If they have a child with special needs, it becomes more in focus. What elder law and disability rights law does is it brings into focus for the clients what is happening now in their life or what might be happening in the future. And that's why I like my timeline, because I got a point in time here, a point in time there, and I got this long line of what happens when you're not so well. And when we talk about elder law and special needs law, we're really talking about helping to try to provide as much in the way of protection and resources for those loved ones that are in that situation. And a basic estate plan, the will, the trust, the powers of attorney, it's a really good first step, but in and of itself, it's insufficient, generally speaking. Now, we have, over the course of years, added things to our even basic level of planning. So, for example, a 40-year-old couple might come to me and they're not thinking about any of this. And they've got either no children or healthy children, and they're not worried about these things. And even though it's not a major topic of discussion in the planning, it's something that we have built in for the purposes of being able to address the what ifs. So in elder care, what I call elder care or disability rights estate planning, what we're doing there is we're bringing those realities that will statistically be part of everyone's lifetime now. If you're if you're alive now and above the age of, I forget exactly what it is, but 60 something, maybe 70, there's about an 80% probability it's going to happen in your lifetime. And it's going to happen to you. Now, that's a terrible reality. Obviously, let's all stay as healthy as we can so that we're in the 20% and not in the 80%. But if that's a reality, and even more so for the people who are already diagnosed with dementia or with some kind of developmental disability or whatever may be happening in their lives, we know that the path they're going to go through, I'm on a path here. This is my visual for my clients. This path is to say, we are on this path together. I know, because I've done this hundreds and hundreds of times, I know some of the hurdles that they're going to confront. I know how the medical system is going to operate and where it dysfunctions at transition points, at discharge, at shift changes, at all these things. Why? Because I was a provider for years as well. I know how the benefits programs work, the Medicare, the Medicaid, the private insurances, the long-term care policies. We know when the system, where the tension points are, where the system can break down. So we become more of a guide through the process. But our legal documents are set out to provide the scope and breadth and flexibility that's needed in order to address these changes and challenges as they arise in people's lives. So even a person that calls me up and says, my brother, this is a real case, my brother is now in a nursing home, skilled nursing facility. He is going to need Medicaid. He's not going to be able to go home. I'm a trustee of a trust for him. And what can I do? So the tension point there was concern for the brother and concern for preservation of the assets. And what we do first is review what's there. I find out that the trust is not effective to protect the assets. So we're going to go to court intentionally. Now, this is a good reason to go to court, to reform that trust so we can have the assets that are held in that trust protected, so that the money will be there, hopefully, for the balance of his lifetime, rather than having to be sucked out to pay for the nursing home care. But then we get into the question of how do we transfer him from this facility, the one he's in, that is only partially certified for Medicaid, which means once he loses his Medicare, short-term Medicare rehab coverage and needs to transition to Medicaid, he's going to have to move from that facility. So we want to transfer him now to a facility that he can stay long-term. Again, these are things we understand, and there are changes that occur through the process because we're dealing with human beings. And if your plan is rigid and it doesn't have the scope of authority or the flexibility to change as it needs to, or to be modified as needed, then you run into more challenges. So an elder care plan is going to focus on that. I'm going to give you one quick example that'll make perfect sense to everyone out there. You have a husband and wife, they're married, they do their estate plan. What happens on the death of the first spouse, Jay?
It goes to this.
With the assets. What happens to the assets on the death of the first spouse?
It's the property of the married of the spouse.
Exactly. In 99.9% of the cases, it's what we call the honey, I love you plan. Now, second marriages and third marriages, a whole different discussion. We don't have enough time, but I also deal with those all the time for obvious reasons. But sure, in that plan, it's a honey, I love you plan. So the well spouse is dutifully taking care of their spouse at home, keeping him or her out of the nursing home, and the well spouse dies before the unwell spouse. What happens? The unwell spouse often ends up in nursing care. If that unwell spouse is in nursing care and the unwell spouse got everything, what's happening to the family wealth?
Draining quickly.
It's being sucked out at the rate of about $120,000 to $150,000 a year on average. That's an average number. If you had an estate plan that would allow for the option not mandatory, because I got flexibility here. If it allows for the option for what's left behind by the first spouse to be protected for the sole benefit of the surviving spouse, anything he or she needs, but also has an added feature, which is exempt from Medicaid eligibility, we now get to save the family wealth. We don't have the spouse running out of money. There's extra needs that he or she may have, even though Medicaid is paying for the basic room and board and care. And we have gotten a better result because we've included the elder care planning provisions for asset protection. I know that was a lot to take in, Jay.
It's so many different topics, and like you said, and we don't have 10 hours, and of course people won't want to, but this is such a tremendous number of highlights, stopping points, milestones that people can consider. Last thing, we have a society where there is still wrongdoing. I mean, is the bottom line.
Yes.
In your view, your experience, maybe your exposure to different walks of life that wouldn't be different from mine. The idea, the concept of elder abuse is out there. Next year is more people will turn 65 in the United States next year than ever. So can you tell me, is this like hype, or is this real, and how serious, rampant is it?
Yeah. Well, nobody has to question that. If you've got an internet account and an email and a cell phone, you probably already know that you've been spammed and scammed before. It is rampant. It is a rampant problem. And, those of us who are hyper vigilant about it, I mean, I won't open up anything if I'm not 100% sure where it came from, because it only takes opening one thing to infect everything, right? So, and then what do they get? Well, they're not standing there with a gun to your head, but now they've got access to all your personal data and everything else. And if they want to they want to exploit you, they can do it. But yes, it is a rampant problem. Elders, of course, are more susceptible, whether it's loneliness or feebleness or just, too trusting because they were brought up in an era where you could, send your kids to walk 2 miles to school at 6:30 in the morning or 7 o'clock in the morning when it's still dark outside. We don't live in that world anymore. For most of us, it's certainly in urban areas. And so the reality is that we do live in a society that we have to, be aware. And so exploitation specifically is a huge issue. Exploitation is the concern for how you protect the elder's money, right? And then there's the abuse, which is, of course, we know what abuse is, and neglect. There's 3 prongs to that whole issue: abuse, neglect, and exploitation. Yes, anytime that happens, it's a tragedy. It's terrible, and our systems, at least in Michigan, are not perfect on how they respond to them. Whether it's the Adult Protective Services system, some counties are better than other counties, but for the most part, they're just a Band-Aid on the problem. And some lawyers are more proactive in how they respond to those things for their clients. Some are less so. Some banks are more proactive. Again, some are less so. I see bankers, by the way, doing estate planning and facilitating exploitation. I've witnessed it and had to go back and undo it. Yeah. Wow. Why? Well, I mean, it happens innocently enough, right? Sure. Child takes parent, or niece takes aunt, or whatever it is, to the bank, and it's innocent enough. They just need me to be on the account so I can also write checks because, blah, blah, blah. And maybe it even it happens in the best of scenarios with no intention to do anything different. And if that person who has the authority all of a sudden runs into problems, it's like, well, there's an extra money there they'll never know, or I'll pay it back, right? And then you end up with, it's sort of like when you learn to drive and you're going in a residential street, you're going 18 miles an hour, and you're stopping at the stop sign, and you're looking both ways, and you're waiting, and then you're going. 2 weeks later, you're going 35 and blowing through the stop sign,
Right.
right? Because what happens is it's human nature. We start to do something, and then we can realize we can push. And so it is important to have some level of checks and balances so you can help avoid the obvious problem of what happens when you put someone in charge if they are larceny minded, or they might be weak and not be able to resist. And my first answer is wrong person.
Right.
Right. And then the challenge is always, well, who else do I have? Well, let's talk through the options. And there are often we get to good options and choices. Anyway, great question. Huge area. We've had a number of cases where we've helped undo problems, and we've had other cases where there's nothing we can do. We just have to stop the bleeding. We've gotten the Attorney General's office involved, sometimes the FBI involved. It really depends on the nature of what's happening.
Sandy, we've run out of time, but I had very, very high expectations for our conversation today. I've had this set of expectations for years, in fact.
Well,
we're going to include the links to the information packet that you had everywhere that we share this broadcast, and hopefully you'll join us again.
Well, thank you very much. I'll do it anytime, Jay. I really appreciate the opportunity again to talk with you and your audience. It's always a pleasure. If there's anything I can do, for anybody who's in Michigan, I don't practice in other states, but if you need somebody like me and you are in another state, I can help guide you because I've got colleagues all over the country.
He's Sandy Mall. He's my friend. We've been associated, worked together for a number of years. Thank you so much.
Thank you. Be well.